Can you hear me? All right, everybody, we're going to quiet down. Michael, speak.
We're going to go ahead and get started. You can't really... Doug, turn this up. We're going to go ahead and get started.
So we have someone's keys that I think you left at the table. If you haven't checked in, do so afterwards. And we have opening remarks here from Mayor Brinkman, and then our training will begin with Tammy Sonoy. I'm Kirsten Crawford, the city attorney. I think I know most of you. I would like to also introduce tonight a new assistant city attorney here, Kristen Schleidorden. And some of you will get to know Kristen at our new boards and commissions meetings. Thank you so much for coming.
I'll just yell. Hi, welcome. I want to thank all of you for taking the time this evening to come to the training, and also to really thank each and every one of you for coming forward and volunteering to serve on a board or commission, and for your civic mindedness in doing so. The boards and commissions are a real important aspect to the functioning of the government in the city. Council cannot be all places at all times, and there's so many different issues that come up, and there's so many different interests within the city. And so having boards and commissions where we can have a focus in some of those areas is really key to keeping us well informed and keeping us able to make better decisions regarding those types of issues. And the boards and commissions feed us that information. You guys are really a key and integral part in that. And you all some of you will spend more time on your boards and commissions than others, but regardless, you will be, doing your weekly or monthly meetings, and we understand the time commitment that takes, and we just want to thank you so much for that. As board and commission members, you are actually moving into a different role within the community, and while you're still a citizen and you're still part of the community at that level, you also have kind of elevated yourself to a new level as a board and commission member. And so there are different different aspects of your behavior that have to be taken into account, and you'll be learning some more of that this evening. It's certainly not scary and not bad. It's actually wonderful, but it is something that I think you need to take into consideration as you move through your days. Your relationship with council continues to be a very important role, as I said earlier. Each of your boards and commissions has a liaison to a staff liaison, and most of them have a council liaison. And one of the things that's real important is as you're going through your meetings and your issues and dealing with things, it's real important to remember that the staff liaison is a benefit to you, where if you've got some things that you feel need to be elevated to the level of the city attorney or to the level of the city manager, those liaisons are exactly where you should go for that. And then the city manager and the city attorney are really the key people who can help work through some of the issues that may arise. I tell you this because both those positions are direct reports to council. So if need be, then they can elevate good or bad to council. So you do have a line to council through these liaisons and through these staff members. And I really recommend that you take advantage of that as you need to, and just know that you have full support from all the key members. Also, this evening, I think that the training is going to be very, very beneficial. If you've served on a board or commission, you're going to learn some new things. If you're brand new to it, you're going to learn a lot of new things. And Tammy Sonoy is absolutely fantastic. She's chief counsel for SURSA, or general counsel for SURSA. And we had her come to the council, and she spent about an hour and a half telling us all the things we shouldn't do and the things we can do and the things that will get us into trouble and the things that keep us out of trouble. And it was really, really informative and very educational. And it was also real eye-opening as to what type of volatility you can put yourself in if you're not real careful. It's easy to be careful, it's easy to do it right, but you just have to know what that route is. And so Tammy is incredibly interesting and practical in her speech with you, and so I think you'll learn a great deal, and we certainly continue to talk about all the lessons we've learned. So I guess to conclude, get you guys started, I just want to let you know that, again, thank you so much. This is good. You're going to have a great time serving and have fun with it, enjoy it, and it's a new relationship with the city, and I'm looking forward to hopefully getting to know each of you all a little bit better. And don't forget that we are going to have a big party in June for the council and commission's dinner. So you'll all be getting invitations to that, and it's a great opportunity for us to say thank you. So I hope you all plan to come to that. So enjoy your meeting, and we'll see you around, I guess.
Well, good evening, everybody. My name is Tammy Tenoy, and I'm the General Counsel and Claims Manager for CIRSA. And CIRSA stands for the Colorado Intergovernmental Risk Sharing Agency. And we are your public entity self-insurance pool. So if there is a claim made against the city or its officials or its boards or commissions, and it's a claim that's within the scope of coverage that is provided by CIRSA, then we do step up to defend you and indemnify you. And so we consider ourselves to be your partner in liability matters. Tonight I'm going to be talking about do's and don'ts for meetings and quasi-judicial proceedings. So I know there are many different boards and commissions represented here tonight. Some of you do have quasi-judicial functions, and I'll talk about that a little bit more. Others of you serve in an advisory policy recommendation type of capacity, and so the quasi-judicial suggestions I'll be making tonight don't necessarily have direct pertinence to your work, but I do have some general meeting suggestions as well. Just by way of background, before I joined CIRSA full-time in 2002, I was in private practice representing municipalities along the Front Range. And among the things I did was to represent city councils as well as boards and commissions. And so I had the opportunity to observe directly the ways in which boards and commissions either could get themselves into trouble or stay out of trouble. A good part of my private practice was also serving in a hearing officer capacity. That is, I had a quasi-judicial role in several municipalities, including Denver, Aurora, Lakewood, and several others. And in that capacity, I had the opportunity to see the ways in which I could get myself into trouble or stay out of trouble, as it were. And I did actually get into trouble on one occasion. There was one quasi-judicial matter where I actually was sued for a civil rights violation. An allegation was made that I had violated somebody's civil rights, constitutional rights, in the course of conducting a hearing. I'm here to tell you that I did get out of that case without any liability, but it's one of those situations that I think we all dread when serving in this kind of capacity, and so there are ways to avoid that kind of problem. One disclaimer that I want to make right off is that occasionally attorneys will have differences of opinion with one another. And so in the event that there is any inconsistency between the training suggestions that I make tonight and the legal advice of your city attorney, well, please remember that your city attorney is always right and I am always wrong. So please keep that in mind should there be any variation. So the topics I want to go through tonight for about the next hour, first I want to set the stage in terms of legislative versus quasi-judicial, that kind of thing, and talk about legal issues. And then I want to move into some practical suggestions for meetings and hearings. And then finally we'll conclude with some special issues. So please do stop me at any point if you have any questions about the suggestions that I'm about to make. To set the stage, how many of you are new Board or Commission members? Okay, looks like a good proportion of you are new board members. So when you became a member of a board or commission, your role and your relationship to the city actually did change quite dramatically. Previously, you were a citizen of Littleton, but now you're really a public official. Previously, you may have been an outsider to municipal government in Littleton, but now you are part of the ultimate insiders. You may have been a critic of the way things were being done, and that may have propelled you to seek your position, but now you are the representative of that which you might once have criticized. There might have been a single issue that piqued your interest in serving, but now you are, within your jurisdiction, the all issues decision maker. Did you all take an oath of office when you came onto your board or commission? Okay, I'll skip this portion of the presentation then, but I think by becoming board and commission members, you do make a commitment to stay within the parameters of your job description, if you will, because that's what you were put into your position to accomplish. And I think clearly you make a commitment to lawful conduct, and in the quasi-judicial setting in particular, that commitment does include some very specific conduct requirements that I'll be getting into in a moment. And of course, I think taking office includes a commitment to ethical practices, including the avoidance of sitting on matters in which you have a conflict of interest or a financial conflict, and you have a code of ethics in this regard that does apply to you. You may have sought your position because of some dissatisfaction with the status quo and the belief that by your participation you could make things better. When I was a municipal attorney, our firm kind of laughingly called ourselves specialists in troubled municipalities. And these are municipalities where there were frequently recall elections in between regular elections. And so I got to meet elected officials who would come into office with kind of a chip on their shoulders. They were outsiders and they were proud of it. And sometimes they would maintain that outsider perspective after they had taken office. But as I mentioned previously, once you were appointed to a board or commission, you did become part of the ultimate insiders. And so that outsider perspective may not necessarily fit. It may cause misunderstandings of your role that can increase the risk of liability for yourself or for the city. Also, you are part of a collaborative decision-making body. That is, you get together in meetings and you exercise your powers and responsibilities in a collective fashion. So as individual appointed officials, there's really nothing you can do alone. And so consensus building is critical, and consensus building cannot happen without a sense of mutual trust and respect and a sense of cohesion. And in that regard, I haven't figured out a better description for this, but I feel as though there's a commitment that has to be made to equality of information on the board or commission. That is to say that each member of the board or commission should be on equal footing, common ground, with respect to the information that is the basis upon which you act. And so to the extent that there's an inequality of information, then I feel as though you're kind of getting away from the ingredients you need to build that sense of mutual cohesion. how can you all be equal partners in making sound decisions if you do not have equality of information? So transparency in terms of giving and receiving information, I think also is a part of developing that sense of cohesion. Does each of you obtain information? Is it furnished to you in a public meeting, some place where all of you are on the same footing so that everybody hears it from the same place at the same time? So a few years ago, I was giving this talk, and towards the end, the city manager, and city managers are very smart people, and they often cut to the chase with their questions. And this manager said to me, well, this is all well and good, Tammy, that you've come here to talk about meetings with us, but you're our SRSA attorney. What in the world does this have to do with liability? And I realized I'd really never made that connection in terms of good meeting practices and liability. So, for one thing, have you ever had to endure a really long meeting, like any meeting that goes beyond 10:30, 11? My experience with long meetings is that the longer a meeting goes, the greater the potential for missteps. And Kirsten, I don't know about you, but my ability to spot the constitutional violation goes way down after 10:30 or 11. And so short meetings really are a risk management technique. The same is true for disorderly or disorganized or contentious meetings. So when emotions get the better of everybody, the likelihood for missteps is much higher. Also, missteps in procedure can either originate from yourself or other participants, such as citizens and applicants. And sometimes these missteps originate from misunderstanding the nature of the decision that you're making. And so one of the things that I hope to go through tonight is the ability to pigeonhole any particular decision in terms of, is it quasi-legislative so that there's one set of rules of conduct that apply, or is it quasi-judicial so that another set of rules of conduct apply? The bottom line is that, especially in the quasi-judicial context, if a misstep is bad enough, then it can be enough to form an allegation that you violated some portion of the federal Constitution. And the thing about process is it is the one thing that is within your control, right? The quality of the testimony or information that you receive, not always within your control, right? The laws that you have to apply in making a decision or recommendation may not be within your control, right? But providing a sound procedure always is within your control. And so it's always a shame when liability arises from something that you could have been able to control. So let's go quickly through the distinctions and functions, the pigeonholing of the nature of your decisions. So a legislative or quasi-legislative or policy type decision basically is a prospective decision. So from here on out, we are deciding or we are recommending that this is the way things should be. So the classic example of a legislative decision is passing an ordinance. So when the City Council passes an ordinance of prospective application to apply to everybody in the class that's drawn in by the legislation, then that's a legislative matter. So think state legislature. Well, sorry, I don't want to analogize you to the state legislature. That would be a terrible insult, but you see what I mean. The legislature acts in a purely legislative capacity, and so there's a set of rules of conduct that are okay. I started my first legal job as a lobbyist for the Colorado Municipal League, and my job description was as follows. I was to go into a legislative hearing, pull a legislator out of the hearing, whisper in his or her ear, tell them how I wanted them to vote, send them back into the hearing, and hope that they voted my way. Is this a lawful activity? Maybe shouldn't be, but last time I checked it still was. But, that's part of the rules of engagement in a legislative context. It's okay for citizens or professional lobbyists to come in and try to influence the thinking of a legislator so that, one hopes he or she will vote your way. But what if I, as a budding young attorney, had said to myself, this lobbying thing really works well. Maybe I ought to run over to the Court of Appeals, pull out a judge, and see if I can try this lobbying stuff on her. Would that have been appropriate conduct on my part? No, right? Because the rules of engagement change in a judicial or courtroom setting. And so had I done that, I probably wouldn't be here talking to you today. So quasi-judicial actions are when you are acting in a judge-like capacity. And so some of your boards and commissions regularly, almost exclusively act in a quasi-judicial capacity. So may I see my Planning Commission members? Okay, yeah. You guys are not all clustered together. You're kind of intermingling. That's nice. So most of what you do is quasi-judicial in nature. That is, you listen to testimony and evidence. You apply that testimony and evidence to an already existing set of legal standards, and then you come up with what you think is the correct decision or recommendation. So that's very much what a judge does. Any local licensing authority members here, liquor licensing? Okay. Much of what you do is also quasi-judicial, right? You listen to evidence and testimony from applicants. You apply that evidence and testimony to the liquor code and any ordinances that may pertain, and then you come up with the correct decision. So, very different type of decision making and a different set of rules apply. So in the quasi-judicial context, if you've done your job properly, you've listened to the evidence and testimony, you've correctly applied the law and come up with a decision, then you're in great shape, right? Because upon any appeal, your decision likely will be upheld, and any other recourse is likely going to be unavailable. Are you familiar with the concept of a Rule 106 action? Have you had a few of those? No? I'm an attorney. Ah, you're an attorney, okay. Preaching to the choir here, aren't I? So a Rule 106 action. Oh. You didn't have to admit that, but... So the great thing about a Rule 106 action is if you've done your job properly, then the chances that your decision will be overturned are pretty low. However, even if your decision was absolutely correct, if you failed to follow the proper procedures in getting there, then you could have a constitutional violation. The Constitution guarantees, among other things, procedural due process. And so that means if somebody's property interests are at stake, then the city is required to provide notice and a fair hearing before a neutral and impartial set of decision makers. That's what the Constitution requires in the quasi-judicial context. So, remember to first pigeonhole your action. Is it legislative or quasi-judicial? Because if it's quasi-judicial, then these procedural due process requirements do kick in. So, in quasi-judicial matters, it's kind of odd to say this, but the way you arrive at your decision is actually almost more important than the substance of the decision itself, because the process is what it's all about. A good process is what the Constitution guarantees when people's property interests are at stake. So as Quasi-judicial board or commission members, have you been assigned a black robe by the City of Littleton? No? Nobody got a black robe. My recommendation to quasi-judicial boards is that each member immediately purchase a black robe, wear it to the post office, wear it to the supermarket. I guarantee nobody will bother you at that point. But failing the actual donning of a black robe, my suggestion, if you've got a quasi-judicial decision pending before you, is to put on the mental black robe and comport your conduct accordingly. Make sure those who encounter you comport their conduct accordingly. So as examples of improper conduct, if it were done by a judge, now what if you had a matter pending in a courtroom and you found out that the person who is going to judge your case was going out there looking for witnesses against you? Would you be a little troubled by that? It should be troubling because that judge has stepped out of a judicial role and seems to be taking some kind of advocacy type role or investigative type role. And so when you're acting in a quasi-judicial capacity, you really do have to think of yourselves as judges. Judges are passive receivers, relatively speaking, of information, right? They get the evidence and testimony that's presented to them. They don't go out there and gather evidence or look for evidence or say, maybe I ought to be talking to this side rather than this side more. They receive the evidence and then they apply that to the law and come to a decision. So your conduct should mirror that. Would you be bothered if you had a judge that you knew was deciding your case and then you found out that your opponent had called the judge privately to try to tell him a few things before your trial? That would be troubling, wouldn't it? And so, again, when you're acting in a quasi-judicial capacity, these kinds of ex parte or outside the hearing room contacts really need to be avoided. Sometimes that's easier said than done in a municipal government context. Citizens expect to have access to their board and commission members. But if the matter that they want to talk to you about is quasi-judicial, then you really have to say, please come to the hearing so that we can all hear what you want to say. Equality of information, all of us need to be able to hear what you have to say. If they don't want to come to your meeting or hearing, then at a minimum, let them know what the process is for getting written comments into the record of the matter. Or what about getting too chummy with one side or another? I've seen this happen in municipal government where somebody with a stake in your decision will think, maybe if I take Chuck out to lunch, right, and fill his ear with all of the reasons why my proposal is so great, then he can carry my water with the rest of the board or commission. Is that an appropriate role for Chuck?
Sure.
Oh.
No.
Okay. Maybe I should have prepped you ahead of time, sorry. But it would not be appropriate, right? Because again, there's this idea of equality of information. And so if one guy is, prepped to be the advocate, then he's stepped outside of a quasi-judicial role if he has a quasi-judicial role. And obviously, if a judge has a financial stake in his own decision, you would not want him or her to participate in it. And judges, at least in theory, cannot and do not ignore the law or the facts in reaching a decision. And so this is something that you, if you're acting in a quasi-judicial capacity, have to keep in mind for your own decisions. So, this is maybe more relevant for the city council, but if you ever made a campaign promise, for instance, right, or a commitment of some kind, that commitment could be inconsistent with the law or the facts that you hear at a hearing. And if that's what happens, then you have to set aside your promises, your preconceived notion, and say, you know, despite what I thought I was going to decide when I was sitting here, now that I'm sitting here, I will base my decision only on the facts and only on the applicable law. Public statements. Do any of you go on Facebook? Or write letters to the editor, or go on radio interviews, or, you know, otherwise speak out in public? You know, some of the things you say in public could end up coming back to hurt you. So if you're acting in a quasi-judicial capacity and you make a public statement, maybe on Facebook, you know, no more liquor licenses in Littleton. We have too many as it is, right? If you were to make that your Facebook status for the day, could that be a problem? It could, right? Because those are not among the legal criteria for granting or denying you liquor licenses. And so you really have to watch what you say, because it could come back to cast doubt on your impartiality or otherwise reflect poorly on the city. Now, when any of you who make quasi-judicial decisions, do you ever do this? I'm going to cast my vote, and I would like to explain why I'm voting the way I'm going to vote. Ever do that? That's kind of scary to me. You know, if you're confident enough that your bench rulings will pass muster, then go ahead and do it. But you could be causing your city attorney to go gray before her time. It happened to me. When I was a city attorney, I had a city council that was voting on an extremely controversial land use matter. So it was quasi-judicial, a site-specific land use plan. Extremely controversial because a yes vote would have turned this city into the medical waste capital of their county. And as you can imagine, many citizens did not want their city to become the medical waste capital of the county. So there was a vote taken at 1 a.m., violating one of my risk management rules, and one of the council members raised his hand and said, I'm going to vote no, and I'd like to explain why. He said, I know we've heard testimony until 1 a.m., but I really don't care what the testimony was. You see a problem there? Yeah, and then he went on to say, I was already persuaded by all of the citizens who called me before this hearing. Anybody see a problem there? Yeah, right. He admitted to ex parte contacts, and then he admitted that he didn't care about the evidence, and then he admitted that he wasn't going to apply the legal criteria in the land use code. So he really put himself and the city in huge jeopardy. Had the no votes carried the day, then he really would have provided a roadmap for suing the city, I think. Thankfully, the yeses carried the day. Even more thankfully, the citizens came in with initiative, referendum, and recall petitions and put a halt to the entire idea of this city becoming the medical waste capital of that county. But, yes? Good question. Should that member have recused himself at that point? You know, had there been a mechanism to do so, I think that perhaps the mayor or council president, the presiding officer, should have said, council member, if you're unable to make an unbiased decision, perhaps you should consider recusing yourself. I think that would have been a good way to cleanse the process a little. And he might have been happy to recuse himself because, you know, that wouldn't have been a yes vote necessarily. So don't explain your vote if you can help it. Let your vote speak for itself and then say no more. Yes?
In past years, the Planning Commission was encouraged to give their findings of fact during the deliberation after public testimony was closed. Are you discouraging that? We were, like I say, past years encouraged
Yeah. Yeah, good question. So should quasi-judicial boards and commissions have findings of fact to accompany their final decision? I think that's a different matter because findings of fact are adopted by the body as part of the motion. So I think that's a great idea. I would encourage that to happen. I would use your city attorney and your planning staff to assist you in crafting good findings of fact, but that's a great idea. It's a wholly different thing from individual members saying, this is the basis of my vote. But if it's made a part of the commission's vote, then I think that's a great thing and really a way to elevate the defensibility of your decision.
Verbally given by individuals during the deliberation.
Yeah, but as long as, made part of the decision of the body, I'm not troubled by that.
Yeah,
Okay.
I think what
Yes.
he's saying is that each member could have a different finding of fact. I think that's what he's concerned about, is that each one said, I found the sky to be orange, another said, I found it to be
Yeah.
blue, another said it's yellow.
So typically, we're going to put in our proposed motions the criteria that you as the body should be looking at, and that when you adopt the criteria in voting on the motion, that would form the basis of the findings of your facts. So they should not be different. That's why we do make our staff recommendations, precisely to address that issue.
Yeah, so comments you make during deliberations may be a little bit different from the findings of fact that you adopt as a body. But, I think the findings of fact really are the operative part of your decision, the operative support for your decision. Yes?
In items that are discussed in the community for long periods of time before they ever get to the quasi-judicial ballpark, when does the curtain go up when you have to start saying, I can't talk to you about this?
Yeah, that's an excellent question. At what point do these rules kick in quasi-judicial matters? So if you're a board or commission member, I think you always have to give yourself an out, okay, to say, this is what I said then, but I am sitting in a different place now. So, even if you're talking about stuff that isn't quasi-judicial now, if there's a foreseeable chance that it could come before you in a quasi-judicial capacity, then I think you need to be cautious about what you say and how to say it. I'll give you an example. So I had a couple of candidates who had become elected by the time they came to my training. And so they confessed to me that they had taken a position on something that was likely to come before them as council members. And indeed, that's what happened. But what they said during their campaigns was, well, as I sit here now, I think this is the way that I would feel about this thing happening. And so he gave himself an out. I thought that was pretty smart on his part to say, as I sit here now, right? Because once he's elected, he's taken his office and he's sitting there, right? He can say, well, I'm not sitting there now. And now I've taken an oath and I'm bound to listen to the evidence and apply the applicable criteria and vote accordingly. So I think you have to leave yourself an out when taking a position on matters that could come before you in a quasi-judicial capacity. The sort of counterexample to that, I had 2 council members who, while running for office, actually signed con petitions for proposed liquor applications. Was that a problem? I think so, because they took a position. I am against the issuance of this liquor license. So then how could they sit credibly as the local licensing authority and say, yeah, I took that position, but sure, I'll be neutral. So in that case, I think the city attorney did recommend that they consider recusing themselves, and that's what happened. So, bottom line, Abraham Lincoln said this many years ago, men should utter nothing for which they would not willingly be responsible through time and eternity. Anything you put out there, potentially could come back to hurt your impartiality. And so you really have to be cautious about saying it. Sure, you didn't check your First Amendment rights at the door when you became a board or commission member, but it's really hard once you take that position to say, time out, I'm speaking as a citizen now, right? The community is not going to recognize any ability on your part to say, I'm taking this hat off and speaking as a private citizen now. That's a difficult distinction, I think, to try to make. Okay, moving on to some practical suggestions for meetings and hearings. So have you ever had the contentious meeting or public hearing where fire codes are about to be violated by the crowd trying to get into the room? Had a few of those? Yeah, it happens from time to time. My belief is that when citizens attend meetings and public hearings, they don't show up wanting to be confrontational or rude or disruptive. I think for the most part, they have a sense of discomfort about being here, about being, on the other side of the podium, doing public speaking. And so that discomfort sometimes comes across as being rude or confrontational or disruptive. So, participants, I think, want to know what the rules of conduct are. And over time, I think that they can be trained to expect and engage in courteous conduct. On the other hand, if discourteous conduct is the norm in your board or commission, then you're training them to be rowdy and discourteous too. So either way, you can teach and lead by example. So I would say establish a certain level of formality in your board or commission meetings. You may feel kind of sheepish about that, but I think it makes sense to require a certain level of formality. So for instance, make sure you always require recognition by the chairperson before somebody is allowed to speak. If you feel as though somebody's discussion is veering off of the issues and into personal attacks, then you've really got to gavel them back to order and make sure that they focus on issues and not personal attacks. Staff bashing sometimes happens, right? The planner is so stupid. That's not a very constructive approach, but I disagree with his recommendations on the project for the following reasons. That would be a more constructive approach. And so, make sure that you start training people to focus on the issues and and help them learn that staff bashing is not an acceptable way to approach the issues. And of course, don't participate in staff bashing yourself. There is nothing more demoralizing than that happening on this side of the podium. Do you ever have the peanut gallery rumblings where people sit in the back of the room and they mutter, sometimes to the point where it begins to interfere with your discussions? And I think that if you consistently require speakers to be recognized by the chair and gavel to a halt any rumblings that start interfering with your meetings, that you can, again, begin to train that out of your audience. The other thing that sometimes happens at meetings is that people will stand on this side of the podium and they'll be like, I want to know why, or I want to ask you why, or I want some answers on, right? And they put you on the spot to try to answer them tonight. But the opportunity for public comments should not be viewed as a public inquisition opportunities. So when that starts happening, again, start training those speakers to understand that they are welcome to make comments, but their questions may not necessarily be answered right then and there. That the purpose of public comments is not to put you as board and commission members on the spot. If you all regularly do hearings, then I would start to maintain a library of standard opening scripts for each type of hearing. So, if you're going to have a rezoning application, then a standard hearing format for that would make sense, or a new liquor license, or a show cause. Having standard scripts for each type of hearing makes sense. As I say, I was a hearing officer for a good 15 or more years, and from the first day to the last day of my work as a hearing officer, I did rely greatly on one of these hearing scripts for each type of hearing. You can also have standard post-hearing motions for each type of quasi-judicial decision that you make. So do you have a sign-up process if you have a lot of people who want to talk to you that night? It's a good idea to maintain either a sign-up sheet or a sign-up card just for your hearings. And consider dividing up that sheet or those cards into each matter, and then are you planning to speak pro or con? That way you can organize the testimony in a fashion that makes sense. Another thing that you might consider doing if you've got quasi-judicial matters is, guide the public on appropriate conduct. So you have your boards and commission handbook, and it might be helpful for citizens to understand what the rules of engagement are. Do you swear in speakers or witnesses for your quasi-judicial matters? No, you don't? Okay.
Only on some of the boards, but that's a good idea.
Yeah. I liked swearing in all speakers on quasi-judicial matters for a couple of reasons. Number one, it kind of sends the signal. This is quasi-judicial, and we have a different set of rules that now apply. It also actually enhances the evidentiary value of the speaker's statements. I remember one case I had that went on an appeal on a Rule 106, and the court highlighted the fact that this was the sworn testimony of the witness that seemed to mean something from the court's standpoint. So, at first you may have a little bit of snickering by people who are being forced to raise their right hand and, solemnly swear, etc. But I think over time, it's a good thing to do. If you have time limits in place, be sure and enforce them, especially if you have a lot of speakers signed up at night, at the meeting. So, get maybe staff to have the clock so that they can keep track of time. It's a difficult process for the person presiding over the hearing to also keep time, so try to get a staff member to hold the timer and enforce the time. Do you consider the meeting room setup when you do a hearing? A courtroom style setup is actually ideal if you're going to have 2 or more sides in a matter. Because the worst thing that can happen is that you don't really have a side for each party to retreat to, and so everybody's kind of gathering around the podium, and then they start pointing fingers at each other and talking to each other, right? Because they have no place to retreat to. So consider the setup of your room if you've got a issue that could potentially be adversarial. Also put the podium between the 2 sides tables so that there's a neutral zone and then each party has a side. Presiding officers. Who are the presiding officers, the chairpersons? Yeah. Was each of you issued a gavel? No gavels? Yeah. You really should have a gavel, I think, just in case. It lends that air of authority, I think, to have a hammer in your hand. So have a gavel. And if you hear the peanut gallery starting to rumble, you can, start softly hitting that gavel at first and then give it a good hit on the, the piece of wood if it becomes too noisy. And you don't have to be nasty about it. You can, blame, your hearing or the acoustics of the room to say, people in the back need to stop talking because we can't hear ourselves. Do things ever get really heated during the course of the meeting? You kind of sense the temperature in the room starting to rise, and you're thinking, a riot's going to break out next? Right? That ever happen? If that feels like it might be about to happen, there's nothing wrong with one of the members of the board or commission saying, Mr. Chairman, could we have a 10-minute recess? right? And then try to retreat away from the audience. Don't go through the audience, because you'll be lobbied if you try to go through the audience. But, retreat and let things cool down a little bit. We've talked about the pro or con. It's nice to know who's pro and who's con, because then you can organize it to say, I'm going to call on all the pros first, and then I'm going to call on all the cons next. Sometimes when you group speakers that way, a beautiful thing happens. The speakers kind of see who's speaking on their side, who's speaking on their side, and they sort of informally gather together, you'll be the spokesperson for this side, right? And then it really does make the testimony a lot more efficient, and people can self-edit their comments. They're free to say, I agree with what the previous speaker said. Whereas if you're bouncing back and forth between pro and con, everybody feels obliged to, repeat the same thing that somebody said 2 or 3 speakers ago. So don't hesitate to give a reminder if you've got a lot of people signed up to testify. Please keep your comments brief. Feel free to agree with the prior speaker. There's nothing wrong with saying me too in this context. People may appreciate knowing that that's an okay thing to do. Sometimes I've seen this organization, this self-organization process work so wonderfully that if there's legal counsel that's sort of representing one side, that they start organizing the witnesses. Have you ever had that happen? Yeah, isn't that wonderful? I've had that happen at liquor licensing authority meetings where, there's often an attorney on each side, and they'll start doing the organizing of the witnesses for you, and that's wonderful. Inappropriate confrontations or inquisitions. So when you have witnesses start pointing their faces away from you, the board or commission, and towards one another, then that's a signal that something inappropriate is about to happen. Many was the time that I, as a hearing officer, would say to my witness, hey, point your face at me, right? So don't hesitate to say that. Please direct your remarks to us, the commission or board, and not at one another, because the worst thing that can happen is for them to start arguing and forget that you, the board or commission, are even there. And in that regard, if the applicant is speaking first, and then you start calling on other witnesses, have the applicant retreat, sit down before you call the other witnesses. Because if you have the applicant still hanging out here, then the likelihood that questions or comments will start getting directed at them goes way up. Sometimes instead of giving you information or testimony, people will start asking questions. It's hard for people to think of their comments in terms of, this is testimony, this is evidence. And so sometimes you'll have people who, I want to know why, right? That doesn't give you any evidence, right? Questions are not evidence. So kind of start training people who are insisting on asking questions rather than making comments or giving you information to not do that. Don't encourage those questions. So, you can, don't answer those questions, but what you can say is, that's a good question, Some of us have written it down, and maybe there will be an appropriate opportunity for that question to be asked. But don't set up the expectation to somebody who's speaking to you that their question will be answered right now. Personal attacks, berating, or name-calling, if that happens, pick up the gavel and make sure that it stops. Sometimes there's a question about who gets to cross-examine, right? Have you ever encountered that as the Planning Commission or other quasi-judicial board or commission? I want to ask a question too. Cross-examinations should not be allowed except by parties represented by attorneys, and only then by their attorneys. And so don't allow the questions back and forth. Does anybody ever come up to testify on a particular issue, and then they'll say, and while I'm here, can I talk about? Yeah, that happens. Make sure that you've set aside a general public comment period and then refer the speaker to that public comment period so that they're not, messing up the beautiful record of your hearing on that particular issue with stray comments. You can teach and lead by example, so your own demeanor, the way you relate with one another, really is a model for the way people come and talk to you. So don't be baited. You always have the last word because you're the ones who take the vote. And so don't be baited into responding or arguing by somebody who wants to be argumentative. And never allow the temperature in the room to rise by yelling back. Let it go, take the high road. Again, you always have the last word. If you feel as though the tension in the room is rising in a hearing or meeting, then one thing you might consider doing is softening your voice, right? You can't outshout somebody who's angry or wants to yell, and so try techniques that de-escalate rather than escalate the situation. And again, remember, you can always ask for a recess, a timeout, to allow things to cool off. Have you ever had matters that are so controversial that you feel like you need to check your tires as you drive away from City Hall that night? I've had a few of those. You really do need to plan for those. If you feel as though a hearing or meeting is going to be controversial or emotionally charged, then talk with the staff about the possibility of having, a police presence. Think about things like an escape route. I'm sure you all have seen the videos where violence broke out at meetings. And so, you want to think about the possibility of stuff like that happening and consider things like an escape route. Do you ever have an overflow crowd so that there aren't even enough seats in the room? Talk about a way to make the audience mad, right? To turn them away. That's a real problem. And so if you think a matter is going to be controversial, plan ahead by, either having some ability for them to listen in via TV or move to a space that can accommodate more people. So in terms of personal conduct do's and don'ts, and these have to do with quasi-judicial matters, not so much with other advisory issues. But in quasi-judicial matters, the essence of a good hearing is fairness and the appearance of fairness. So we talked about the pro and con petitions. Don't sign them with respect to matters that may come before you as a board or commission. Obviously, don't make up your mind before the hearing. That would be a big no-no. Don't speak with one side or the other before the hearing. Those are ex parte contacts, and they're problematic. If you have a financial interest, don't participate. Disclose the financial interest and recuse yourself. There is a code of ethics provision in the city code, and it does give you rules of conduct for boards and commissions. You've got to know what the proper legal criteria are and apply those legal criteria. So don't make your decision based upon considerations that are not part of the legal criteria. If you know something that influences your decision, but it is not part of the record of the hearing, then you have no business considering that. So that requires that you unknow or unlearn things that you are aware of if they were not part of what came out in the hearing. It's somewhat artificial, but you have to set aside, everything you know unless it was part of the testimony in the hearing. Yes?
Can you comment on the difference between bringing with you your inherent expertise as a professional, as, say, an architect on the historic board or something, where you may be able to draw on past experience, which might be appropriate as opposed to bringing with you prejudged ideas or I think maybe it needs a little more
Yeah, that's a very good distinction. You know, part of the reason why you were selected for your particular board or commission is the particular background and perspective that you bring to that board or commission. So, you know, certainly nobody would be suggesting that you set aside your expertise in a particular field. That's part of the reason why you bring so much value to your board or commission. Having said that, you know, let's say that you're an architect sitting on a board that has an architectural type of perspective. You know, you're not being asked to be the super architect, right, above other architects who might have participated in whatever that proposal was, but you have a unique and valuable perspective to bring in terms of asking questions that may help shed light for everybody. But, you know, if you know that a particular applicant is a scoundrel because you and his family have been feuding for generations, right, that would be the kind of thing you know, but you may not make that part of your decision making unless, you know, it comes out in testimony that indeed here's the police record and yes, he is a scoundrel, right? So I don't know if there's anything you want to add to that.
More issues of personal bias than it is, would it be appropriate, taking the architect's example again, to say, well, I've been personally involved with 7 other projects where they used this design and they all fell over. I mean,
yeah.
Where's the line?
Yeah, that's a good question. You know, again, you're not asked to be the super architect over this, but I think it's a good occasion for you to ask questions to elicit testimony from others to address some underlying concerns you may have as a result of your own background and experience. But to say, you know, I know for a fact that 7 other projects have failed and of this nature have failed, and that's why I'm voting no, you know, that might be straying from the legal criteria. So, you know, I think you can use your background to elicit information, again, for the entire board to be able to consider, but don't act upon it yourself. So legal, yes, Chuck.
I mean, the historic preservation work is going to be on Main Street and 7. So a lot of people in the next couple of minutes.
Oh, okay.
It's nothing to do with this presentation.
Sure, Chuck.
And I'll call you for lunch.
I appreciate the heads up. Legal criteria worksheets. I worked with the Board of Adjustment some years ago, and the City Council was very concerned about the Board of Adjustment and the quality of their decision making. It seemed as though they were just kind of, you know, coming from left field on every decision that they made. And so finally I got out the land use code and the provisions on variances, which were of greatest concern, and I realized that the variance portions of the code were so complicated that they actually had to find the existence of 18 different legal criteria before they could grant a variance. Did they know that? No, nobody told them that. So it was like, no wonder their decisions seemed so strange. But once I prepared for them a legal criteria worksheet, kind of a checklist, you know, did we hear evidence on this, this, and this? All 18 of the criteria. The quality of their decision making went way up. And so if you've got complicated legal criteria, do consider asking for a legal criteria worksheet or checklist. So I think we've talked a lot about ex parte contacts. Really the bottom line on ex parte contacts, attempts to lobby you outside the hearing room as individuals, is that they disempower you as decision makers. Yes?
Wouldn't an appropriate way to use the knowledge that the 7 previous projects have all collapsed to say, sir, are you aware of project X? Did you know it collapsed? Are you aware of project B? Did you know it collapsed? That would be a way to, would that not be a way, appropriate way to bring information in?
It might be. One thing you want to be careful about is questions that are more like testimony by a board or commission member. So if you were to say, did you know it collapsed? And the applicant looks back at you with blank eyes and says, never heard of such a thing, right, then that information is kind of sitting out there in limbo. You know, is it evidence or was it just a question? And so you want to make sure that your questions are designed to elicit testimony from others as opposed to being testimony in and of themselves. So yeah, I think trying to get more information, you know, how would you compare this project with the project that failed here 2 years ago? You know, asking questions like that might draw out either the differences or the similarities that might be enough for you to, you know, be concerned about. And that's a very good question. So ex parte contacts in the quasi-judicial decision-making context disempower you as a decision maker. You know, you're going in sort of appearance is that you will be impartial, you will be neutral, you will be a fair decision maker. The courts accord you this presumption of impartiality. But once you have too many ex parte contacts, then that presumption that you're a neutral, fair, unbiased decision maker can really be cast into doubt. And there are numerous court decisions in this regard where somebody's improper ex parte contact ended up disempowering the decision maker. So how do you fend off ex parte contacts? Well, you know, you can't really start the lecture on the distinction between legislative and quasi-judicial matters in a supermarket conversation, but, you know, maybe one thing you can say is, you know, as a board, we've committed to equality of information, and so I really would like everybody on my board to hear what you have to say because it's important, so please come to the hearing. You know, if you cast it that way, equality of information, then you don't have to go into all of the legal niceties of quasi-judicial and procedural due process, et cetera. Or you can play the blame the city attorney game and say, my attorney says I can't talk to you. But you know, that may be an inadequate explanation from the standpoint of the citizen. But you know, try to educate them as much as you can, but if nothing else, try to let them understand that what they say is important and has value and so needs to be stated to everybody on the board or commission, not just one. Yes?
When does ex parte begin?
When does ex parte begin? Good question. So if you've got a pending quasi-judicial matter, that is, it's, you know, on the agenda, or you know that it's scheduled to be on the agenda, then clearly, right, any communication outside the hearing room to one individual is going to be an ex parte contact. I think if you reasonably know that it's going to come to your agenda in the foreseeable future, then you should be cautious about ex parte contacts. I don't know, Kirsten, if you have any thoughts about when.
I would say if it's reasonably foreseeable,
Yeah.
I'd back it up to that point.
Okay.
I thought you said that once an application is made, then it's process.
Yeah, for sure. Once the application is made, it's improper. I would say even, you know, going a bit out past that, if it's foreseeable that an application is going to be coming in, I think you ought to start following those rules. Yes?
I would just say that if someone starts talking to you about an issue, you're put on notice at that moment because they have no reason to be talking to you unless they expect you to rule on their issue.
Yeah, you know, excellent question. Always, you know, examine the motives, right? Why are they wanting to talk to you about this? So that they can influence your decision at some time, whether it be in the near future or a little bit further out. So, yeah, you should be put on notice. I think the minute somebody wants to talk to you that, why are they wanting to talk to me about this? So, did I see any other hands up? Okay. So, I want to mention this because it was a kind of a horrible inadvertent situation that led to a due process violation, and it involved a SURSA member. So we had a board of adjustment, and they took testimony on a variance application. And the applicant came in and talked, and strangely, the chairman looked around the room and didn't see any neighbors in opposition. So he said, thank you, applicant, for your testimony. We're not going to take any more testimony tonight, but the hour is late. We won't be doing anything except taking the matter up for a decision at our next regular meeting. So applicant went home happy, thinking his application was going to be granted. And then a bunch of citizens all of a sudden walk in. We are so sorry that we are late for the hearing. And I understand you've closed the hearing, but could you please reopen it and let us have our say? What do you think the chairman did? He reopened the hearing, let them have their say. Was that a problem? Yeah, because the applicant had gone home with the assurance that no more testimony would be taken. The chairman reopened the hearing not out of any malicious desire to deprive the applicant of his due process rights. He was doing that out of courtesy, right? But he blundered into a constitutional violation, and we ended up having to settle the matter for a pretty hefty amount of money because of that blunder. It wasn't even a deliberate, constitutional violation, but hey, it was bad enough to amount to a due process violation. So, if you've got controversial matters, then do rely on your city attorney and staff to assist you with making findings of fact, because those are the groundwork for affirming your decision. If you feel as though you want to see draft findings and conclusions, then there are certainly ways in which you can do that. I had boards and commissions that would actually direct me to write 2 sets of findings, one in favor of and one against, and then we would show up with both, and they would talk a little and adopt one set. But do let your final decisions speak for you, and try not to make any individual bench rulings. A couple of special issues. So, should you have a council liaison or an ex officio council member sitting on a quasi-judicial board or commission? This question sometimes arises in the planning commission context, where either the council or the planning commission will say, hey, I think it would make sense to have a council member sitting on the planning commission. And oddly enough, there's a state statute that allows that for statutory non-home rule municipalities. But looking at that statute, I see that it's been in place since the early 70s. Quasi-judicial decision-making principles have evolved significantly since then. And so I am a little bit troubled by the idea of having a city council member sitting on a planning commission or other lower quasi-judicial decision-making body. I think it makes things difficult for that council member in terms of being able to sort out, did I hear this evidence before the planning commission, or did I hear it at the city council? And when you think about sort of equality of information, right, that kind of goes against that principle of equality of information, because that one individual has been able to hear information from 2 different hearings, 2 different places. So I do have some concerns about the idea of having an ex officio city council member on the planning commission or other quasi-judicial decision or body. So, are there guidelines for board and commission members to contact members of the city council on issues of common interest? So I guess this would be in the nature of an ex parte contact between a board or commission member and a member of the city council. Here, I think we have to start by pigeonholing the issue. If it's quasi-judicial, then I would say an elevated standard applies, and it would be troubling to me if I were to hear that one member of a board or commission then went to the city council and said, hey, as the Board of Adjustment, I know we made this decision, and council member, I'd like to fill you in on some of the deep background about our decision, right? That would be troubling to me. If it was a policy type of issue, quasi-legislative, policy, it wouldn't bother me as much from a strictly legal standpoint, because it wouldn't be an improper ex parte contact in a quasi-judicial setting, but it would still bother me, I think. When you think about equality of information, right, if one council member has a signal in to the thinking of one planning commission member, then that council member's contributing or ending up in an inequality of information situation. Also, that one commission member could have, I guess, an outsized influence in terms of that council member's thinking. I know my board or commission had this vote, but I want to tell you how I feel about it, right? Then that one member of the board or commission, I think, has a disproportionate potential power, and maybe speaking for himself rather than the commission, but who knows? I think it becomes difficult to juggle the hats when you start engaging on one-on-one conversations between, on a topic that is of common interest between your board and commission and the city council. So I guess I would encourage you to allow your board or commission's decisions or recommendations to speak for themselves and refrain to the extent possible from engaging in additional communications. I just feel like it violates my sense of that, fair territory, equality of information. Are there any questions about that or other matters? Yes, Michael.
One thing that I would add, because I know this has come up as a concern for different folks, and one of the things we've been working on the Boards and Commissions Task Force is to set up periodic study sessions between the advisory and quasi-judicial boards and the City Council. I don't mean to be speaking to the folks behind me, but I can't turn. Because to get to the evenness of communication that Tammy's speaking to, in order to have that occur, rather than having it on an individual basis where Paul wants to go and talk with an individual council member, we're going to provide that opportunity for the entire board to speak to the entire council, and that dialogue on whatever the issue or concern is relative to administrative policy, whatever it might be, can occur in that more public arena and maintain the evenness. So just something that we're putting in place, and it'll be probably more common with those boards and commissions that are more direct in the quasi-judicial realm around ordinance modifications and things like that, but you all will have an opportunity at least once a year, and we'll do it as needed.
Yeah, that's
Thanks.
great. Yeah, that puts everybody on equal footing, and I prefer what you just said, evenness of information to equality of information, so I'm going to steal that from you, Michael. So are there any other questions or discussion? If not, thank you all very much.